Hello, everyone. I'm Vince White. I'm an employment attorney, and on this channel, we publicly posted questions from YouTube users getting folks the answers they need from an employment attorney. We are live for at least 1 hour, hopefully longer. I'll start with the first question. Also, please forgive my cough. If you don't like the cough, I am going to try to mute it, but I get it. Not offended. Don't watch the live stream. I can't help it. My stage 4 esophageal cancer, stage 4 lung cancer, stage 4 head and neck cancer are all in remission. I haven't gotten to this in the cancer vlog yet because the cancer vlog got kind of weird. People were reacting kind of poorly to it. So I put that on pause, but I do have a fresh case of stage 1 liver cancer, which I'm not particularly worried about. Stage 1 liver cancer is kind of like baby cancer in comparison to like esophageal cancer or the large tumor that collapsed my right lung, and my right lung remains collapsed. What I do find is as I talk longer, I cough less. So hopefully we get there pretty soon. All right, enough of that. First question from YouTube user ReadBrary1 says, "Hi, Vince. Any Scottish Highlanders coming on the farm yet?" Well, we do have Duncan MacLeod of Clan MacLeod living in our back 11. He has a little hut back there. I think he practices his sword forms. Now, this is a fairly obscure reference to a 1980s, 1990s TV show based on a movie franchise that didn't do very well. I'm trying to be funny. I think what ReadBrary1 is actually referencing is Scottish Highland cattle, which are one of my ambitions. I want to get cattle on the farm. That is on pause. So past 12 months, all the cancer has made things a little crazy. The firm has been doing great, but I have been a little busy. So no cattle yet. We're also switching our farm manager. Farm manager Adam has had some troubles, and he's got his own land now. So we're gonna wish him well. And we have promoted Dan the Hand to farm manager, and it's going very well so far. So Dan the Hand is a little more knowledgeable about farming, animal husbandry, building. If I'm being honest, he is perhaps a more capable builder and carpenter than Adam, although that's arguable. I don't think Adam would agree, and I don't bear any ill will towards Adam. I don't want to deride his skill set, certainly, but I'm very happy with Dan the Hand, and you know, we wish Adam really well. It's been years of Adam living on the property, a separate house on the property, and it's been lovely, you know. So sad to see him go, but excited to see what big things he gets up to in the future. I will say, by all reports, multiple people have told me that Adam liked to say that this farm was his, that this was his farm in town, and people in town would come and talk to me about that. And, you know, that's kind of a bummer. I do know that he was doing that on social media. He had some social media accounts where he did, we'll call it pretend. I don't want to say lie, but he did represent that this farm was his farm. Never has been. Not really an issue, like not something I get super mad about, but it is kind of a legal issue if I let him claim it's his and hold himself out as the owner of this farm. It's got some issues in terms of like squatters' rights and his ability to like make an argument that some piece of the farm is his. So Never really had to address that with him, although it was something that was going on. It is what it is, type of thing. Like everybody's got their own weird needs, right? So that's, I guess, one of his. Next question, Eric, New York. Hello. The New York City Commission on Human Rights said they are trying to settle my case and assign a new attorney investigator to my case. I feel as if nothing will happen this year. How long should I wait? Well, that depends on you. If you want to go to a hearing in the New York City Commission, you wait until they're done. And whatever pace they work at, neither here nor there, you're a little stuck, right? Like you just got to wait it out. The other option is if you cross-file with the EEOC, you could pull out of the New York City Commission. You could get your right to sue letter from the EEOC, and you could proceed to federal court. You could also theoretically go to state court in New York, depending on your claims. I don't know enough about your case to advise you, but those are all the options. And certainly, listen, pull your right to sue letter and is a little fraught in New York now. There's a rogue federal judge who made a finding that makes that a little difficult right now, something we've been contending with. So that's a consideration. You may want to read up on that. I think we do have a video on the channel about it because it's kind of an interesting quandary, especially because the EEOC is so foobar right now. I think we all thought the EEOC would just kind of cease to exist in some way under the current administration. It hasn't. It has been redirected to certain kinds of claims, some of which I agree with. Like, am I really excited about the EEOC spending all its time on like anti-Caucasian discrimination? No, I very much am not. And I'm a little tired of a bunch of caucasies, which is what I refer to my people, the Caucasians. If they'll have me, although I am so white that I am in fact pink. I don't, perhaps I'm too pink to be a Caucasian. But there's some level of when anti-Caucasian discrimination is real. Yes, of course we bring those claims. Of course we help those folks. I will say there is a tremendous number of white men and women, oddly, primarily women, who feel victimized by their skin color. That, to me, seems statistically unlikely. Like, without a doubt, there are individual claims that are absolutely real and they deserve intervention, and our firm would love to help, and the EEOC should help. Like, all the agencies should help, all the judges. These claims can be legitimate. Do I think the EEOC should be redirected to prioritize those claims? No. Conversely, and just to be clear, I don't think the EEOC should be redirected to prioritize those claims. I don't think there's a lot of those claims, and I also think the impact of those claims is lesser, right? Like, if you have, we'll pick one of the more common forms of discrimination, anti-African-American discrimination. And I specify African-American. I'm not even saying anti-Black discrimination, because then we're including Caribbean on African-American and, African immigrant on African-American discrimination. And there's a lot of different forms of anti-African-American discrimination, including all the people who don't like Black people, right? The racists. The impact of anti-African-American discrimination has a long tail because that form of discrimination is so common and so pervasive. So if that person loses their job, the African-American person, the hypothetical that we're talking about here, loses their job due to discrimination, it can be really hard for them to find employment again because of that same discrimination. So the impact can be greater. But I'm just talking. Let's get back to the questions. YouTube user Arkansas001 says, am I protected by OSHA? Whistleblower. If a coworker made an anonymous complaint about supervisor drug use and nothing was done, then we were both written up for insubordination the day the case was closed. I think it depends where you are. Like, I don't know that OSHA is going to protect you, is my most honest answer. One moment, please. I mean, first off, you didn't blow the whistle. I'm not even sure your coworker blew the whistle as per OSHA standards, right? Like, sorry about that. I have a hernia that causes my stomach to just dump stomach acid into my chest cavity, which feels really super. So sometimes I squint in discomfort. Okay. And that is, of course, from the cancer treatment. I think the feeding tube I had back in August, September 2025. Might have been a big contributing factor to that hernia. Anyways, OSHA, off the top of my head, and check with an attorney who handles more workplace safety cases, more OSHA cases specifically, because we don't handle that many. We actually try not to. OSHA is a bit of a nightmare. Damages are low. The agency is kind of more messed up than the EEOC, believe it or not. Very understaffed, years behind its own schedule. And all that. So, check my work here. But it sounds like your coworker may not even qualify as a whistleblower because they complained internally, which I think for OSHA, you have to complain externally. Check that. But also, why would you be protected? You didn't blow the whistle. There's no, like, you can at least make an argument for your coworker. They blew the whistle internally. If that counts, as per OSHA standards or as per the state or local laws of whatever jurisdiction you're in, they may be protected. So too could you, if the state and local laws of whatever jurisdiction you're in protect you. But that might be unlikely, given, again, the fact that you maybe didn't blow the whistle. But again, check that with local counsel. But under OSHA, I don't even know if either of you are protected, frankly. Okay. Peeb81 says, hi, Vince. Thank you for all the videos you made. They've been helpful. They have been so helpful when preparing for my upcoming EEOC mediation with no representation, not by choice. Peeb, I'm really glad to hear those videos were helpful. I always feel ridiculous making these videos, so I'm happy to hear it. What's going on with the hair back there? What's going on with the hair? Ooh, that's not going right. Well, I guess it just kind of is what it is. That's how we're going to do the video. Arkansas001 says, is it discrimination in a hostile work environment if a supervisor made a couple of comments about my race in the past, but now only makes slurs, derogatory statements about other races at work? Well, yeah. I mean, first off, if that person made comments about your race previously, you can still complain about those now, which would then lock in protections against retaliation. But also, these other slurs and derogatory statements about other races, you can still oppose those, right? Like, you don't have to personally be the target of discrimination to oppose it and then lock in retaliation protections, which is different than discrimination itself. The discrimination would have to target you and your protected class. But you can oppose discrimination against anyone and lock in retaliation protections. So hope that helps. Philip Morningwood 747 says, Vince, so excited to see this happen. Thank you. Philip, it's good to see you. I hope all is well. I hope your case is proceeding successfully and quickly, lucratively. Lucratively. That I don't think that's a word. P81 says, when is the best time to share audio recordings admitting fault in regards to a failure to accommodate case? During mediation or let it go to investigation in a wood party state? Okay. So first off, if you have an attorney, strategize this with your attorney. Second off, I would urge you to play a clip or highlight reel. Don't alter the original recordings. Obviously, keep them in their pristine original state. You'll need them as evidence. But if you're going to mediation, you could edit one clip that you feel is especially useful to you, or a highlight reel, right? And it really depends on how much you want to get this mediation done. Like if you want this case settled, I'd take the time and put together a highlight reel, frankly, like just the hits. Now make sure they're actually the hits though. Like there's a lot of people who come in with recordings like, I got these people dead to rights. They're going to give me millions. And then I listen to the recordings as a courtesy and I'm like, yeah, so what did you think the case was? Like what in your mind, when you hear these recordings, how do you think these help you? And what claims do you think they're supporting? And that is a much more common reaction to a recording, if I'm being honest with you, than, oh my God, this is so valuable. We're gonna make it big money, right? Like it just that's usually not what we get with recordings. Most people's recordings are like, hi, yeah, can you fill me in on what you thought this was and how you thought this would help? That is far more common. And sadly, it's getting even more common now that people kind of have this AI derangement disease that's going around. So there's that. All right. Ooh, oh, chat jumped ahead. Oh, Choose Compassion. Choose Compassion's in the chat, everybody. The world's best moderator. Thank you so much, Choose Compassion. It's good to see you. All right, let me go back and answer questions in order here. Philip Morningwood 747 says, question, if one is talking to their attorney on the phone on speaker about the case, if the spouse of plaintiff is around the room and listens to some of it, does that mean the combo is no longer privileged? Okay. All right. So the spouse is a special case to some extent because the spouse is also has some spousal privilege. So I guess I'll give you the most complete answer here. It's going to depend a little bit on the case law of the jurisdiction you're in, depending on how much and to what extent the attorney-client privilege is impaired by the presence of the spouse listening to the conversation. That being said, your spouse listening to the conversation is likely, in most jurisdictions, to impair your privilege less, or even not at all, than if, like, say, your parent or your sibling or your buddy listen into the conversation, right? Like if your parent, your sibling, your buddy listen to the conversation, yeah, that attorney-client privilege gone. It just assume it's not there, right? And listen, that's not hard and fast. Check with local counsel, please. But your spouse, more of a gray area, more degrees of gradient, much more complex. YouTube user Leo Queen 9997. The agency rejected. Hold on. The agency rejected an administrative judge's summary judgment in its favor, saying the AJ failed to address my colorable EPA claim and used incorrect legal standards on my other issues. What does that usually mean? Okay. Leo, I'm sorry. I don't know what agency you're talking about. I don't deal with EPA claims. I don't know. We're employment attorneys. So this might even be in the context of an employment issue, but I don't know what your EPA claim is, and I don't know why the agency would reject a finding in their favor. If I had to hazard a guess, and this is like a bare bones guess, like do not put any stock in this. It sounds like maybe they want a more fully featured ruling. Like they might think that the AJ's summary judgment in its favor is not defensible, and they think they can probably get something better, something a little more concrete to hang their hat on. So they want to actually fight it out with you to put your claim in the ground and be done with this and create favorable case law. But again, wildly guessing. I am Lee, and I am Lean. I am Lee, and a Nicole says, "Hi, Vince. Hi. Hello. Uninvited guest speaker. Good afternoon, Vince and chat. Stay well, Mr. White. Stay well to you as well, uninvited guest speaker. I would like to send an invitation. You could become the invited guest speaker. Please, by all means. Hold forth in chat. I am Lee, and Nicole says, "Hi, Vince. My question is for an EEOC mediation. My employer was open to mediation. My attorney declined and advised that he's being strategic in doing so. He will be filing my lawsuit in a few weeks. Why would an attorney decline mediation at the EEOC level?" Okay, so we actually have videos on this on the channel that are going to be much more fully featured than this. But the only real reason I can see to decline EEOC mediation, I guess, is twofold. I use an example, and I guess I'm going to just confirm something really quick to make sure a gentleman isn't still working somewhere if I use his name. Okay. So my memory just might not be serving me correctly because this gentleman, Chris Kwok, is someone who I remember working at the EEOC as a mediator. When I pull him up, though, he's at JAMS. Now, there doesn't seem to be any record that I can find of him at the EEOC, so perhaps I'm just a moron. Also, take everything I say with a grain of salt, because, you know, as many of you pointed out over the years, I'm a moron. I get things wrong occasionally. Okay, so this gentleman, Chris Kwok, was, I believe, a professor of mine at one point. Certainly, he worked at my law school at one point. He was also a mediator, at least at JAMS, which many of you may be familiar with. JAMS is a mediation ADR outlet. Very expensive, not particularly great, in my opinion. The only thing I would say that really sets JAMS apart in attorney eyes is they've got great spreads. Like the food they put out is really good, which is actually kind of meaningful because if you've watched the mediation preparation playlist, combating low blood sugar during a full day mediation is actually a big factor in getting a case settled. A lot of clients will get upset. They'll lose their appetite on both sides, defendants, plaintiffs, whoever. And as they get, you know, the blood sugar gets lower because they're not eating, they get irritable and aggressive and angry. And then, you know, getting a settlement becomes impossible functionally. So the spread of food that JAMS puts out is meaningful, and also the quality of that food. And I will say, some of the most accomplished eaters that I know who practice law still wax poetic about the cookies at Jams. Like gentlemen who have easily achieved 350, 400 pounds of culinary delight in their life will be like, listen, Jam's a lot of money, but those cookies, they'll make your day. Listen, Jams has good cookies. I'll give them that. I don't think good cookies is a good reason to go with Jams. I think there's much better mediators you could hire. Specifically, I think for the same price as Jams, you could have some of the best mediators in the world, like mediators who mediate conflicts between nations, broker peace between nation states, like really meaningful, really special mediators, charge about the same or less than Jams. Jams, by comparison, is generally okay. Now, I do speak about Chris Kwok here because, in my personal opinion, one fella who we've established recently is a moron. So, take it with a grain of salt. My experience meeting with Chris Kwok was the worst mediation I've ever seen. I don't know how he got a professorship at Hofstra. I don't know how he remains employed as a mediator. My experience was he would just wander off in the middle of conversations. Like he didn't make my client feel heard, which is one of the true powers of like transformative mediation, like making someone feel like they've actually been heard. Like the things they're saying matter. That's a big part of transformative mediation. That's the superpower of transformative mediation. I don't like transformative mediation. I would not, I work as a mediator sometimes. And when I do, I'm certainly not transformative. I don't, I'm not a big fan of the like, let me feel your pain. Tell me, I'm not Bill Clinton. I feel your pain. No. Listen, do I commiserate? Do I sympathize? Yeah, of course. But like, that's not the sole focus of my day as a mediator. And I often think that transformative mediators, that is the only service they provide. So, I think that I'm very skeptical of that. Kwok, I'll go a step further. I don't think he's a good transformative mediator. I don't think he makes clients feel heard. I think he is self-absorbed and kind of fails to pay attention to the clients. I think he also fails to pay attention to some attorneys. Beyond that, though, I will also say he's not very directed in my experience. So like the other wing of mediation is like, hey, dummy, you want 30 mil, huh? Have you noticed you make 20 grand a year? Have you done the math? How many years, you fucking idiot, pardon my language, would you have to work to have made 30 mil in this job? Right. Yeah. You couldn't live long enough. You wouldn't live long enough to do that. Right. That's impossible. Okay. So how do you get the 30 mil? Oh, the emotional damages. Okay. So you think you're going to get functionally what? 29.5 million in emotional damages? What happened to you wasn't that bad. It was bad. I think you were wronged. You were harmed. You were harmed. But I mean, I used to work for a guy, and I have a large group of friends who all work there as well. And this guy would deliver this little speech like, she was harmed. And he did, in fact, talk like that. He's deceased now, so I don't want to speak ill of him. He used to leap on tables and be like, I'll win you millions. And then the attorneys that work for him would have to like sit there and be like, this is like a $60,000 case, you idiot. Like what? Like this person's going to expect millions now. Why would you do that? And his take was like, well, I want him to sign the retainer. I mean, that's not honest. That's not a way to do business. It's also very detrimental to the entire process because like now this person thinks they're going to get millions. They've got the greedies. They got a full-blown case of the greedies based on complete fiction from some jackass who said, I'll win you millions. And now the attorneys who are actually handling the case, the associates and partners in the firm, have to be like, hey, yeah, no, I know the guy, the famous guy with the name on the door did say he'd win you millions, but he also won't take your calls. Right. Like I'm the one working the case. I'm the one drafting the case. We talk, a couple times a week about the case. I think it's notable that you've never seen that guy again. Maybe you should have the conversation with me, not with that guy. And a lot of people are just like, because they're fully in the grip of the greedies, be like, no, I hate you. He's the guy. He knows. And you're like, okay, yeah, all right. So you're gonna get probably $0. You can take this like money that we have on the table now, or I got to be honest with you, I don't think there's any way you win this case, given the evidence you have. And they'll just be like, no, he said I'll win millions. And you're just like, all right. I mean, you can do what you want, I guess. So anyways, yeah, Chris Kwok, he was both incapable of making my clients feel heard, but also incapable of like leaning on either side, being like, hey, stupid. The things you're saying are stupid. Maybe you should make a better decision. Right? Like I'm a neutral third party. I came fresh to this case today. You told me your side, and your side sounds effing dumb. So you can try to tell that to a judge, but I expect you will be in for a very bad day if you go that route. Or you could settle today, right? Like that's also a valuable way to go at mediation. It's not transformative at all. It's very directed, but my estimation of Chris Kwok is that he is incapable both of making clients feel heard, transformative mediation, but also incapable of like any form of directed mediation. So anyways, my recollection was he was working at the EEOC. And to go back to your question, if I thought he was a mediator that was going to mediate an EEOC mediation, I'd be like, yeah, we should probably don't agree to this EEOC mediation. We can do private mediation. Like I'll pony up $5,000. Defense counsel can pony up $5,000. We'll get a real mediator and actually have a meaningful process. By contrast, if Deborah Reich was the mediator at the EEOC level, she's mediated in the New York EEOC office for decades, I believe. I would jump at the chance for EEOC mediation. I thought she was the sun, the moon, and stars of mediation. It's specifically Chris Kwok, who, in my singular opinion, is I'm not even going to say he's a bad mediator. I would actually argue he's not a mediator. Like his presence is almost like a detriment. And I can remember chatting with opposing counsel. Like opposing counsel was like, yo, bro, you want to go talk in the hallway for a second? I'm like, yeah, sure, whatever. We go talk in the hallway, and then we come back, and it's like, hey, mediator Kwok, could you go? Could you like go do something else? I mean, we can probably just take care of this. Like you're actively a detriment to this process. And that is my recollection of appearing before mediator Kwok, who's otherwise a lovely guy. I hope that answers your question. So basically, like, it just could be a really bad mediator, I guess was my answer. The other one is like, maybe your attorney isn't up to speed on the case. Maybe your attorney thinks the case will be worth more in litigation. Maybe your attorney thinks filing on a public docket will put pressure on your employer. But a lot of things that could be in play there. I don't actually know what this one's about. We have a question from Xavier Ramirez, E4D, who says, sir, I apologize for getting all mad. I am tapping out, brother. It's a big A.OL company. Got to focus on good stuff. Not aware of you getting mad. I'm sorry, Xavier, if you got mad. I don't have any idea what you're talking about at all. I don't know if you got mad at me or somebody else. I guess I'm cool with it either way. I don't really care. But I hope you're all right. Killas and Wick says, I am have you already exhausted 180 days. I am have you already exhausted 180 days. Killas and Wick, I'm sorry, I have no idea what you're trying to say. Okay, who's next? I am the Batman says, question. I had an employment attorney who represented me for months. I tried not to pester him. Now I'm told after 3 to 4 months he has no case file, work, or communication, and he dropped the case. What now? I mean, I think it's a little suspect that there's no case file after 3 to 4 months. That's very strange. I mean, I guess it's possible he didn't touch the case. That is some of the issues you see with bad employment attorneys. They don't work the case. They take the case, and if they can't settle it, they just do nothing. Yeah. So I guess that's pretty suspect. I think the what now, to answer your question, is you got to find an attorney who's actually going to do the work. YouTube user Sneebarg says, have you ever seen a case successfully result in the defendants being demoted as part of the judgment? That is not a thing. Judges do not run companies from the bench. Judges will not demote an employee working at the defendant employer as part of a judgment. I've seen it as part of a settlement, but that's incredibly rare, and you should not ask for that as part of your settlement. That is a major obstacle to settling a case. Sometimes employees get stuck on like, this guy's got to be demoted. Got to be demoted. It's the only way I'll settle. It's just like, okay, why do you care about this pissant loser who did dumb shit? They're probably going to fire this guy or woman after your case, but they can't. Well, your case is open because they need a witness. So they got to stay on good terms with this person until your case is over. So be aware of that. Choose Compassion, our moderator, says Vince with many exclamation points. Choose Compassion. It's so lovely to see you. The old Theola Blackmon 3903 says, I was terminated for writing up an accident. And then I was told I was terminated for missing work. And those days were holidays. I do have an attorney. And the case was filed. What's next? I don't know. Ask your attorney. I don't know what stage the case is at. I don't know what's been done. You have an attorney that you're paying. Call the person you're paying. Why are you asking a random guy on the internet? I mean, not to be a dick here, but like, I don't know anything about your case. I don't know the procedural stance of your case. How could I tell you what happened? I don't even know where you filed your case. So I can't even guess, right? I don't even know what jurisdiction you're in. Choose Compassion says, hello, chat. Wonderful. Best moderator in the world. Okay. LG Cognito Fox says, thank you, Vince. I followed your guidance. I followed your guidance and successfully settled the case for a substantial amount. Well done. I did it all myself and took your advice to do all the work for them. I hope God heals you. Thank you. That's very kind of you. I'm so glad you got paid. I'm so glad you got a great result. Very happy for you. Killas and Wick. Your attorney might know that you have a case that has already went past 180 days. So for you to skip mediation and investigation to receive a right to sue letter now, in mediation, all we get is a right to sue letter. You can get it after 180 days without waiting for a 6-month investigation. Yeah. Just to be clear, whether or not you mediate does not impact whether or not you can pull your right to sue letter. You also generally don't have to wait 180 days to pull your right to sue letter. And you don't get a right to sue letter in mediation. That's not part of mediation. Mediation is unrelated to the right to sue letter. It's the same agency, but it's not required nor does it delay the right to sue letter in any meaningful way. I mean, you can't pull the right to sue letter and do mediation. You have to wait for the mediation to be completed, but otherwise they'll just cancel the mediation. I mean, you can pull the right to sue letter, but they'll cancel the mediation because you're going on to another venue, right? Okay. I am the Batman says, would an attorney be more likely to represent me if I have dual OSHA claim? Real quick pause. It is tough to find attorneys who will take on OSHA claims. You can do it. There's people out there who do it, certainly, but they are hard to come by. Going on with the question. But I haven't filed a lawsuit yet, so I'm not technically pro se, but I have exhibits, rebuttals, and pretext evidence. I mean, listen, pro se litigants have a hard time finding counsel because it's really hard to undo what they've done, to fix what they've done to their case. In most cases, 99 out of 100 cases. So maybe that's preferable. Certainly could be. Simply Carefree Baby says, hi, Vince. I got fired by my boss, the CEO, 1 week after notifying her of needing a biopsy for a painful lump in my armpit with a dimple that is causing numbness from my shoulder to my hand. I'm really sorry to hear that. That could be a claim. I would check with local counsel immediately. You might want to hit up our how to find an attorney playlist. And I hope that your health, I hope you get good news with that biopsy. Uninvited guest speaker says, is waiting more than 2 years for an investigation by the New York State Division of Human Rights to complete an investigation commonplace? Yes. Nothing but radio silence filing more than 2 years ago. It's pretty standard. Choose Compassion reminds everyone to hit the like button, please. It's free. It is, in fact, free. And I'll note we have 42 concurrent viewers, but only 17 likes. Now, that's meaningful only because the likes are actually how people see us in the algorithm. It's like the only way that we get attention from YouTube, because we have a pretty esoteric and kind of boring topic, right? Like not that many people want to learn about employment law. So we're pretty small as a channel. We're like, I don't know, 130K subs. And that's, it's small. We're not a channel with millions of viewers. I'm not Casey Neistat or Luke Combs for the Outdoor Boys. I'm just not, we're small. So the like button helps us. The heart button helps us too, but not as much as the like button. Okay, what's next? KRP 935 says, is early neutral evaluation worth it for employment discrimination cases? If someone's being unrealistic or just kind of like out there with their view of the case, then yeah, sometimes it can really help to bring in a neutral to be like, hey, you're saying things that don't make sense. This isn't your day in court, but it's like a simulation of your day in court. And I'm telling you, if I heard this case the way you're setting it out, I would not find it compelling. That's when it's valuable. So it could be. Killas and Wick said, I am Batman. Talking to YouTube user, I am Batman. Attorneys take cases that make sense to them only. That's true. Simply Carefree Baby. She stated performance concerns addressed in the 90-day evaluation 3 months prior to being fired, but the 90-day evaluation stated meets requirements. Sounds like a pretext. Could be part of a claim. Choose Compassion reassures uninvited guest speaker, telling him, I waited. I don't actually know uninvited guest speaker's gender, so I'm sorry about that. I waited more than 2 years. I hated it. Uninvited guest speaker responds, says, that's unfortunate. Thanks for the response. It is. They found probable cause, though. This is Choose Compassion saying they found probable cause. I hope they find the same for you. I do too. And I always applaud Choose Compassion for her efforts in her case. Simply Carefree Baby says, I'm sorry that you're uncomfortable and hope that you get well relief soon. Oh, don't be. Listen, I'm good. Working full time, back in the gym, playing with my kid, getting back out on the farm. Like, I'm fine. My cancer is mostly in remission. Just kind of mopping up the follow-on effects from treatment, right? Like chemo, the radiation, the immunotherapy, and I'm still getting immunotherapy now, and I might get more chemo, but no more radiation, at least not to my chest, maybe to my liver. It's just the treatment causes a lot of damage, and then you kind of got to get that fixed to some extent, and sometimes that's difficult. Ooh. Choose Compassion is pointing out the ratio. So we have 46 people watching concurrently, and we now have 27 likes. Thank you all so much. Amen X says, I'm in California. I took sick leave and was demoted the next day through text message. I have microcytic anemia. I never disclosed it. My HR has now ghosted me after an ambush meeting, and I had an ambush meeting by my manager. Well, and you go on, do I have a case? So I don't have local counsel on the live stream with me here, so I can't answer as to California law. Not allowed. So check with local counsel as to your California rights. There might be specific protections in California tied to sick leave. Hint, 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 hint. Hint, 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 hint. There might be. Check with local counsel. Couldn't tell you if there was or wasn't, but I think you should check with local counsel. Now, you raise a significant issue here. You didn't disclose your disability, the microcytic anemia. You're saying, do I have a case? If you're asking me if you have a disability discrimination case, let me pose a question to you. If you don't tell your employer you have a disability, how in the world could your employer discriminate against you based on that disability, which you did not tell them about, which they did not know about, right? So like, here's an example. If I was secretly, I don't know, I'm a Canadian citizen. I'm also a U.S. citizen, but I'm a Canadian citizen. And I don't disclose my Canadian citizenship. Doesn't really come up in day-to-day life. But if I had an employer, let's say the employer was a big MAGA person, and they got mad at Canada because Canada didn't want to be the 51st state, and they hated Canadians. And incidentally, in the process of them hating Canadians, they also fired me. Could be a case, right? Oh, they hated Canadians. I'm a Canadian citizen. Here's the problem. I didn't tell the employer I'm a Canadian citizen. So then it's not discrimination because they didn't know. See my point? So too with you don't disclose that you have a disability. Whatever your employer does to you then, unless there's a perceived disability issue or they have some other knowledge of a disability, or you have, a new or should have known standard where like things are happening to you or that you're doing things that should give them the inkling that you have a disability. Barring all that, you probably don't have a disability claim because they didn't know. So how could they act on their hate, right? Okay. Whoa. Chat jumped ahead. Oh yeah, and everybody, happy Memorial Day. I don't have the best understanding of what Memorial Day celebrates. I believe it's for the soldiers, the veterans who died in our many wars. So I hope we're all celebrating them, and I hope you're having a good Memorial Day. I hope you're having some time with your family, some time to think about the people who gave it all for the country, all that. All right, what do we have next? Let me find out where we were in chat here. It keeps jumping ahead. I can't find where we were. Let me blow my nose. Well, okay. All right. KRP 935 says a federal court in New York placed a pre-filing injunction on me that is broad in scope, not narrowly tailored and vague in nature. One judge literally rewrote my complaint to justify dismissing my lawsuit. Okay. Here's the thing. Federal judges don't care about you. They're just judges. They're kind of on the bench for life. They don't have a lot of forces on them making them act impartial. So I'm guessing you were doing something kind of funny or aggressive, and that might be what the injunction was tied to. In terms of rewriting your complaint for you, that's very strange. I don't fully know how to take that. I'm guessing you were pro se or a pro se litigant using AI, and the things you were filing were just like hot garbage and nobody can understand them, which is very common with AI or pro se litigants. And I guess at this point, I am differentiating pro se litigants from AI litigants. I think pro se litigants probably are a little bit better off than AI litigants. Like AI is such complete useless trash in this industry, in my opinion. You're welcome to disagree with me. I don't care. I actually don't think you're qualified to have an opinion, which is my own arrogance. And you can take me to task for that by all means. But I assume what you filed might have been garbled or not made sense or, excuse me, failed to state a cause of action. And that might be why they rewrote it. If they did in fact rewrite it, like I don't really know what you mean by that, because that would be a very odd behavior for a judge. You could always appeal if you wanted and raise that strange behavior. Killas and Wick says, I do have this AI obsession too. Sorry to hear that. I am the Batman says, question. Let's say in writing, I have an attorney admission workers' comp. I have an attorney admission workers' comp had bearing on employment decisions. Okay. So a workers' comp decision or workers' comp filing had bearing on employment decisions. I also have them admitting to putting false data in my file with refusals to correct. Good case? Sounds like a workers' comp retaliation case. Certainly could be viable. And valuable. Rebecca McCree, 6230 says, new hire and the job they put you in, you're not physically able. The safety guy even said some men can't do it. Is it okay to go to HR and ask to be moved to a different position, or will I get fired? You might very well be fired because they hired you for a specific role and then you're saying you can't do it. That's one hell of a role if it's so physically demanding that many men can't do it. I'm assuming by your name that you might identify as female. Listen, if you can't do it, you can't do it. You're going to get fired either way. So you might as well ask them for a different role because then at least you got a shot, right? If you can, maybe go to your doctor and get a diagnosis and a reasonable accommodation letter to help you get an accommodation so you can do the job. Might be something. JNT Romero 723 says, Vince, you guys are the best. Thank you so much, JNT Romero. That's very kind of you. KRP 935 says, hit the like button. Vince is a real deal. That's very kind of you, KRP. I am the Batman says, question, what do you think about OSHA STAA statute? Surface Transportation Assistance Act. I don't know anything about it. Sorry. I'm not familiar with it. I don't do a ton of OSHA work. Killas and Wick. My question is, how much impact to a favorable letter of determination from the Unemployment Insurance Agency hold on a retaliation case? A little bit. Unemployment agencies are not generally, I mean, they're one of the lowest courts in the land, and the administrative judges in that agency are, you know, some of the lowest judges in the land. There's lower. You could get like a traffic magistrate, or you could get, depending on where you are, depending on the jurisdiction you're in, depending on how they set up their hierarchy of judges and arbiters and fact finders. So they're just not that important. They don't get a lot of deference from other judges. That's not to say it's not valuable in some way. It could be. Oh, we're almost done with our first hour. I'm going to take a short break. 1 moment, please. All right, I'm back. Oddly, I just got an email from Popeyes being like, yo, we got such a deal for you. We got a coupon here that you can get some chicken tenders for only $12. And that's kind of wild because just chicken tenders, no sides, no nothing, no biscuit. $12 seems like a lot to me. I do love Popeyes, and Popeyes in their email kind of reference that, like, hey, you love our chicken. I do love Popeyes. It is delicious. Far and away better than other fast food, in my opinion. But the idea that they're like, yo, our chicken tendies are usually like $25, but here you can get up to 12, no sides. That's 2026 for you, I guess. I don't know. I guess I'm just being cheap here. I guess it's weird that I'm complaining about the cost of Popeyes because I'm kind of at a stage in my life where the cost of Popeyes should be meaningless to me. But it's the principle of the thing. Just crazy. Just factory farm chicken and a couple of breadcrumbs, and it's $25. I don't know. I mean, listen, those spices, the spice blend, it's good. It's good. Is $25 good? I mean, I paid $25. I pay $25 for Popeyes in some very questionable neighborhoods. I literally was like, I saw like a Kennedy Fried Chicken further down, like a couple blocks further in the neighborhood, and I was like, Kennedy Fried Chicken's pretty good. I would really enjoy that, but like, I kind of grew up knowing if you're in a Kennedy Fried Chicken, like maybe don't be. Maybe that's not a great place for you, especially at night. So I was like looking in the neighborhood, like, am I brave enough to go the extra 3 blocks for Kennedy Fried Chicken? Turns out no. Turns out I'm gonna go ahead and just pony up that $25 for Popeyes. So be it. Uninvited guest speaker says, lower wage earners have a greater probability of being discriminated against, yet higher wage earners get greater rewards for less discriminatory claims. Seems ironic to me. Empty rhetoric, or do you see it? I think it is really, really unfortunate that damages, at least economic damages, are so tied to your earnings, because very, very small claims can be worth a ton of money if you make like $500K a year, right? Like if you get somebody 1 year of wages, but that 1 year of wages is $500,000, you know, for something where they were wronged, but you know, when you hear the claim, you're like, oh yeah, that's unfortunate. I would not love it if that happened to me, right? And then you go and you help a lower wage earner, and you're like, wow, this is a legitimate hate crime with like a sexual assault and enforceable touching, criminal charges. This is horrific. Let's go ahead and shoot for 5 years here, but the person makes 30K. Not going to lie to you, they're going to make a fraction as much as the fellow with the claim ish who made 500K. That sucks. That's unfair. Now, part of why that's happening is, well, part of something that you noted here is lower wage earners have a greater probability of being discriminated against. That's because HR cares a lot more and is better trained when they're adjudicating things for high wage earners for a couple different reasons. It's just a higher part of the company. It's more visible to leadership, so HR is more on it. But also, they hire better HR people because the size of claims for big earners could be huge. And of course, HR exists to protect the company from liability. So you hire better HR where the liabilities could be much higher. But that being said, yeah, I feel your disgust, and I join in it. I do think that economic damages are a meaningful component of damages and should be included in damage calculations. But I also feel like the emotional and punitive damages that could be in play in a case should not be so tied, as they often seem to be, to the earnings potential of that individual. It seems like although by law those are not tied to the earnings potential, people behave like they are in negotiations because they're afraid of the economic damages. So yeah, I share your frustration. Sneebark says, I think the best thing you can do is trust your representation because they're highly likely to do all they can for you. That's generally true. I agree with that. All right. Killis and Wick says, how much impact is a letter to a mediator? Excuse me. Almost no impact. If you're lucky, they'll read it. Arkansas 001 says, what do I do now if management made a different employee take a random drug test instead of the supervisor after a week of the complaint? No wrongdoing found, internal investigation. I don't know. I mean, my original advice to you to talk to local counsel and see if you have a claim is that stands. That's what I would do. Raisha F says, hi, Vince. What to expect at a scheduled 3-hour settlement conference? Why is the settlement scheduled from 1:30 to 4:30 when the courthouse closes at 4:30? Well, it's scheduled from 1:30 to 4:30 because the courthouse closes at 4:30. I don't know what you mean. Like, you want more time? They don't want more time. They're going to tell you, they're going to tell both sides. They're going to lean on both sides, be like, hey, we want this. Assuming this is a judge or a magistrate judge. And I'm assuming this is federal court in New York, just to give you context. So I don't know where you are. I don't know what they're doing necessarily. Things could be different where you are, different procedural stance, different. If it's not federal court, it's going to be state court. It's going to be vastly different. Even different federal courts in different states can be different. But I digress. They scheduled it for 3 hours because that's what they want to give you. They want to lean on both sides and try to force a settlement. They don't want to go longer. If people refuse, they're good. They're not going to give you a full mediation. Choose Compassion posted our mediation preparation playlist, which I am very grateful for. I'm the Batman said, question, what states can you take cases in, Vince? All 50 states. It would be an honor to have a lawyer like you to represent as representation, but I don't know what states you can take cases in. So we do take cases in all 50 states. We have local counsel. You should not necessarily want to hire us. We are more expensive than local counsel in most jurisdictions, although not all. There's a few where I'm like, really? You losers locally, you're charging more than our firm? Because like I read your submissions and I'm not positive that you can read. So that certainly happens. But generally speaking, local counsel can be fantastic, and you should go with local counsel first and only hire us if local counsel is not a good option for you for some reason. The Airlock says, are travel expenses to and from therapy treatments considered recoupable damages? Not under the federal laws. Your jurisdiction may have state or local laws that calculate that differently. Check with local counsel. Also, I mean, why are you focused on that? How much could that possibly be? How far are you traveling for therapy? Like, this is diminishing returns. Like, you're just worried about what I assume is a very small amount of money in a case that maybe is, valuable in other ways. So I wouldn't spend your time on this. King Will, happy Memorial Day. Happy Memorial Day, King Will. I may need you if my civil RICO, if my civil RICO R&R is favorable. You posted a docket number. I don't know if that's a great idea. You can delete that, I believe. Northern District of Georgia, Ogletree Deacons of Counsel and Morgan Lewis partner, 11 other counts also. Probably not going to be super interested in that case, but if you contact our intake, we're happy to take a look. What is the going hourly rate for a professional mediator? Anywhere from, I guess you asked both. Well, I guess you don't ask both. You specify not an arbitrator, but I'll answer both because I have free will. What is the going rate for a professional mediator, not an arbitrator? Mediators charge anywhere from $200 an hour to I've seen $2,500 an hour. I charge the same as I charge when I. Somebody deleted something. Okay. Oh, King Will, good idea. What is the going hourly rate for a professional mediator? I charge $1,160 an hour, $1,160, which is the same as what I charge as an arbitrator. Arbitrators, are kind of similarly priced. I've seen arbitrators as cheap as $150 an hour. But again, I charge $1,160 per hour when I sit as an arbitrator, and I am familiar with arbitrators who now charge more than me. I believe for a period of time I was the highest or the second highest paid employment arbitrator in the country. That is no longer true. People have raised their rates, and I guess I'm just lagging behind. But I am getting a lot more arbitration work, huge volumes of arbitration work right now. So, I don't know that I need to raise my rates necessarily. I'm Batman says, choose compassion. I called the intake center when I was told, was told I would be given a call today. Today is a holiday. None of the attorneys are going to call you today. In my case, I have a very thin discipline they use to justify termination, but many contradictions in documents. I'm sure you're going to hear from somebody tomorrow, one way or the other. Ian Evans 9367 says, is it illegal for opposing employer's attorney to contact a prosecutor to worsen an outcome of pending legal matters to get you to resign or as a punishment for not resigning? Well, what are they doing? I guess. Like, are they just calling the prosecutor and giving them evidence? I don't know that that's necessarily illegal. If they're calling the prosecutor and bribing them, deeply unethical and illegal. If they're, putting pressure on the prosecutor, inappropriate, certainly. I think maybe an ethical issue. I guess my question is, why would the prosecutor bow to some employment defense attorney? Prosecutors are generally not the best attorneys, but they often think they are. So, they have a lot of pride, maybe undeserved, but, and listen, they're certainly good prosecutors. I'm not speaking about everybody, but I'm used to some very shabby chic prosecutors in New York State. Yeah, I guess it would depend on the context of what's going on. The Incredible Boom Boom. Also just to, I don't know, let me think about this. I'm going to change all the identifying characteristics. There's a plaintiff that is trying to run away and steal our contingent percentage, like our percentage on the case. And that plaintiff happens to have committed multiple felonies. And as part of the whole situation, defense counsel is contacting the prosecutor, trying to get them to move forward faster with the felony charges on this plaintiff. And the plaintiff's in this weird position where the settlement that my firm brokered would protect them entirely from these charges. It would resolve everything. There would be no issue anymore. But because they're trying to rob us, because they're like a career criminal, allegedly, although very much, I think, just career criminals, the settlement's not in place yet because defense counsel's like, yeah, you're not going to steal Vince's money. Obviously your attorney's getting paid. We're not going to just hand you a bunch of cash and then have this problem with Vince's firm. So now they're going forward with the charges to apply pressure. And this plaintiff is, angry. Angry that, he or she is on the hook for these felonies and it's going to kind of destroy their life. But their take is I should be able to rob other people with impunity. So how can they do this? And it's just well, this is normal, right? I can't do it in that scenario because we previously represented that person and have a fiduciary duty, but certainly defense counsel can, as long as I'm not getting defense counsel to do it, right? So that's completely normal. And I'm not going to lie to you. If I have a defendant facing criminal charges, I'll often call the DA or the prosecutor, the ADA specifically designed to that case, specifically assigned to that case. And I'll be like, hey, I got a team of attorneys over here with a ton of evidence we put together for you. It's going to make your job easier in adjudicating this case against this person, this criminal case. Would you like it? And from my perspective, great tactic, right? Because what I want is for this defendant to plead guilty in the criminal case to get a settlement, so they don't have to do as much time. Once they pled guilty, it's really easy for me to point out to a jury or a judge or a mediator, hey, actually, the defendant here, the bad actor, has sworn before a court of law under oath that he did it. He did it. He says he did it. So how is he here today saying we might not win when dead to rights, your only witness says, yeah, I did it, and it was under oath, right? So that's certainly a tactic I use all the time. I can actually remember a case years ago. I got a bunch of white stuff, fuzzies, on my polo today. I remember a case where I had a New York State Division of Human Rights director swearing up and down that it was impossible for the bad actor to do what we are alleging he had done, which was grope our client while walking next to her. And the director was like, that can't be. It's impossible. We actually hired actors and sent them to see her. She's a monster. She was a political appointee, which is trash. I'm sure she knows who I'm. In this moment, she's like, how dare you? Some Cuomo era trash. But her take was like, this couldn't possibly happen. So we sent actors to demonstrate that you can walk next to someone and like grope them. That's physically possible. But then because the guy pled guilty to doing it to get a better sentence in criminal court, we were like, director, I understand that you believe this couldn't physically happen, even though we sent actors to show you that it physically happened because they did it in front of you. So obviously it's possible. But beyond that, the gentleman you're trying to find innocent, gentleman I use loosely here, he says he did it. In fact, he swore he did it. So both people present, my client, the plaintiff, the victim, who has been forcibly touched, and the bad actor who did the forcible touching, the only two people present both say this happened. So it's really weird that you're running around saying it didn't happen because you weren't there. You were not there. Everyone who's there says it happened. In fact, one gentleman says it happened, even though it is tremendously to his detriment to admit that it happened. And she was still kind of like, I don't know. I don't see it. I don't see how it could happen. And you're just like, well, you ignorant POS. Like, the actors showed you how it could happen. And then she had some weird like theory of like, well, I don't know if this guy is as spry as your actors. I didn't send young actors. I sent actors of mature age for that specific reason. Okay, next question. The Incredible Boom Boom says, hey, Vince, good to see you live again. Incredible Boom, it's good to see you. I know that you're not opposed to representing people pre-termination. That is true. That is accurate. Have you had any experience bringing pre-termination suit and a later termination one? I have. Many, many times. And that's actually one of the things I often tell attorneys who want to say, like, oh, I don't take pre-termination suits because they're not as valuable, potentially. I often point out, hey, the client could later be terminated, and then you have a massive retaliation claim, and your case is already moving. It's tremendous. It's really great. It's bad for the client. It's bad for their quality of life. But in terms of the case valuation, it's huge. Okay. I am the Batman says, question, Vince, is intentional affliction of emotional distress a real claim in employment law, or is the evidence burden so high that it's a pipe dream? Okay. Is it real? Yes. Do I use it? Yes, I do. Is it often a sign that the more valuable claims are in distress for lack of evidence or some legal issue? It is. Also, it's a bit of a catch-all. So you're absolutely correct. You're highlighting the evidentiary burden for that claim can be difficult. Also, courts and judges don't love that claim. Also, defense counsel don't deal with it often. So they might take a no settlement stance with that one. So there's lots of downsides, but it is a useful tool, and it can rehab a case in which the claim is uncertain, or the evidence you have might not be what you want to meet. There might be some issue with the evidence in terms of meeting the burdens of the federal laws or the state laws specifically on point for discrimination or sexual harassment. But yes, it's certainly a real claim, and I do use it. Happy ASS Creature says, hey, Mr. Vince, good to see you. Good to see you too, Creatures. Sneebark says, is it rare for an arbitration agreement to preserve a plaintiff's right to take the story to a journalist? Yes. Although there's some jurisdictions where I believe that might be required now. Check with local counsel. The Incredible Boom Boom says, my situation is veering towards this possibility. Attorney and I are obviously aware of res judicata and preclusion, etc. Okay, so your case is veering towards the affliction of emotional distress. Okay, so that's not a good sign. Listen, it could work out. It's not the end of the road, but it is a bit of a Hail Mary, is what I would say. Often you can see that as a bit of a Hail Mary. Master Blake 212 says, what do you think about the lack of quality legal research tools available to pro se litigants? And what is the impact of that? And what the impact of that is on litigants and the courts? I'm working on a free research tool. So I guess I'll point out, you have the same access to research tools that I do. You could pay for Westlaw. You can pay for Lexitas, LexisNexis, whatever you want to use. They'll take your money. There's nothing stopping you. So the way you phrase this is the lack of quality research tools available to pro se litigants. Not true. It's available. It is expensive, right? It's easy for me to shell out $600 a month on LexisNexis. But it might be difficult for a pro se litigant to do that. I don't want to presume to know a pro se litigant's finances, but often they're pro se because they can't afford counsel. So maybe they don't have the money for the research tool. Now, there are free tools like Google Scholar and whatever you're using. There's a bunch of them. They're generally a little bit inferior, but I'll say this. They're inferior in a way that may be irrelevant for most pro se litigants, because most pro se litigants may not be capable of differentiating and making the proper arguments, even if they had the proper research tool. Now, don't get me wrong. There's always that 1%, maybe 2% of pro se litigants that absolutely can do it I'm not claiming attorneys are all geniuses. We have training, but certainly there are pro se litigants who can outperform the bottom third, maybe even the bottom half of attorneys. Like, that's the reality. So it's rare, right? Killis and Swick says the greedies. The greedies are a dark thing. They're very sad to see it happen. Yeah. Choose Compassion says, I'll get you millions. That's hypothetical. Steve. Darn it, Steve. I don't know who Steve is. Steve is, I think, a name that I use a lot when I'm talking nonsense or hypotheticals. Happy ASS Creature says, I finally got an attorney to file in federal court for disability discrimination. April 6th was my file date. I haven't had to talk with my attorney yet. How should I approach my attorney? I'd say hi. Going with a list of questions. Hear them out. Be respectful. Have a nice give and take. But make sure you get good communication. Make sure you get good answers. We have a whole playlist of videos. I think it's entitled Having Frank Settlement Discussions with Your Attorney. I think that's a really good starting place for how to speak with your attorney. Like, your attorney works for you. It is a service-based industry. Many attorneys don't know that, or pretend not to know that, or try to ignore that. It's not viable. At the end of the day, we serve our client. Our client is the boss. We have a duty of loyalty to our client. And then we go fight with the other side, right? So it's really important to remember, you fight with the other side, you serve your client. The problem in our industry is many attorneys want to fight with everybody. They want to pressure their client to do what they think is good, and then they want to fight with the other side, and they don't want to have that service aspect of the case of the industry mess up their day too much. And I think that's both wrong and misguided. I also think it results in worse outcomes. I know it does, because according to a LexisNexis study, my firm is doing more of these cases nationwide than any other firm in the country. And, I mean, the only explanation for that is, in my opinion, we're putting up results and we're service oriented. Our communication is better than average. We serve at the behest of our clients. We understand that. And you combine that attitude with the irrational aggression pointed outward, pointed towards the other side only. I think that's the key. So, just remember that, and hold your attorney accountable to that. It'd be what I say. My advice. Choose Compassion posted the Finding an Employment Attorney playlist. Killis and Wick said, but why settlement a Title VII when the company is guilty of Section 1981? Well, I assume your settlement would be global, right? You'd be settling Title VII and 1981 claims at the same time. I don't think you would just settle Title VII claims and leave the 1981 unsettled. That would not be something the employer would want to agree to, but it also wouldn't be something you would agree to, because, 1981 might give you some access to additional damages if the 1981 claim has legs. Happy ASS Creature said, I've been through all the playlists. Oh, that's wonderful. I really hope they helped you out in some way. Happy ASS Creature said, I called over 100 firms. I got only one firm to take my case without selling my house. It's not easy. I think lawyers are afraid to work with autistic people. I actually do agree with you. I think there's a lot of attorneys who steer clear of, I actually have a video on the channel about this. There's a lot of attorneys who steer clear of mental health conditions, because the wear and tear on the attorneys can be tremendous. One of the examples I use is I have a tremendous amount of experience in my life with people dealing with bipolar conditions. The entirety of my family, with the exception of myself and my grandfather, suffer from, I believe, diagnosed bipolar conditions. They live with bipolar. So while the average attorney might be like, hell no, I'm not representing some bipolar person, because listen, some bipolar people during certain parts of their cycle are aggressive or abusive or a variety of other things. And that can be really hard on the case, really hard on the attorneys. It's just a reality. Like if someone has a mental health disability that causes them to mistreat the attorneys trying to help them, or even like lose their temper during a deposition or a mediation or something like that, that's a problem, right? Now, while admitting it's a problem, I don't think that attorneys can turn their back on those claims because one, that's discrimination. You know, they're not telling you, oh, I'm not taking your case because you're dealing with a bipolar condition, because that would be, frankly, illegal. But in any jurisdiction I'm aware of. Beyond that, you're leaving a lot of really good claims on the table because in this country, we have a tremendous issue with folks hating people with mental health disabilities and reacting really poorly to those folks. Ooh, the burps. I'm sorry. And to your point about people living with autism, yeah, I think that's an issue too. I think there can be communication issues. I think that attorneys have their own kind of discriminatory issues and where they have assumptions, preconceived notions, where they're like, oh, maybe this person wasn't communicating well. Maybe what they're telling me is just their perception because they're on the spectrum. That is also wrong, in my opinion, and is gross. We do have a couple of attorneys who are diagnosed to be on various points of the spectrum in our firm. Not many, but enough that we can certainly put together a team that commiserates with someone living with autism. So I agree with you. I think that's common that many lawyers are afraid to work with people living with autism. Killers and Swick explains what he was saying, or she, I don't know. Happy ASS Creatures said, I had one of those. They dropped me with only a few weeks till the deadline, was going pro se, but I got an attorney. I'm glad you got an attorney. Pierre Willis 1019 says, in your experience, are clients that are managers or work in a legal adjacent career, HR, compliance, etc., to be better or worse clients, or it depends? It depends. I don't really. Yeah, I don't think it's a real problem for me. I don't mind people who have. We represent attorneys too, frankly, so it's really not an issue. Barry's yes says, can you inform a pauperous? How hard is it this way? Well, listen, the standards can be a little different in every state, every jurisdiction. So that's, check with local counsel. But there is an added stumbling block here where courts will say, why would I give you a free counsel when you could just take a contingency option from some firm and you could obtain counsel, right? That's an issue that comes up a lot. But it is winnable. I mean, I don't see it in civil court too often. I guess I've seen people try, but I have seen it granted. Cedric Holding, the EEOC investigator, tried to set up a fact-finding, I think you mean fact-finding conference, not factory-finding conference. Probably just a typo, probably autofill. The respondent didn't want to attend. Should I ask for the right to sue or wait for determination? Depends. If you have an attorney and lined up and you want to go to federal court, ask for the right to sue. You could wait for the EEOC to do whatever it's going to do, but they don't generally do too much. So it might be a waste of your time. Kills and Wick said, former pauperist, you didn't have income. Document your lack of money, financial obligations. The judge decides that you don't have money to file. Accurate. Antonio Head says, great information. Antonio, that's very kind. Carmen Chappelle, 2595 says, hello, Vincent. Hello, Carmen. Saint LJ79 says, Vincent, happy holidays. I've been watching you for 4 months consecutive. I think I've watched all of your videos. Here's a question. I hope the videos were helpful. Saint LJ goes on. I have a mediation case for EEOC this week against a trucking company in regards to retaliation inning and firing 1 day after notifying management as witnesses to racial discrimination. Chat jumped ahead. Let me go back. It's hard to find this in chat. I'm sorry. Oh, okay. I think I found it. St. LJ goes on. I have a mediation case for the EEOC this week against a trucking company in regards to retaliation, firing after notifying management as witnesses to racial discrimination. Is there a question? What is the question? Sorry, I thought there was a question there. Are you just telling me? I mean, congratulations. I hope the mediation goes well. Yeah, I don't see your question. Sorry about that. Cedric Holding says, Roses, why does the EEOC investigator want to lowball me? I didn't receive unemployment. I asked her for 4 business days. Okay. I asked for 14 business days while I seek counsel. Should I wait for determination or request a right to sue as an investigation? What happens if she closes my case? Okay. I don't know if the EEOC investigator is lowballing you or if you're not properly calculating your damages. I can't say. I don't know anything about the situation. I would urge you to get counsel and then have counsel do evaluation of your claims and see how it matches up with what the investigator is saying, because you might not be correct. It's very common for people to have trouble calculating their damages. So just be aware of that. That being said, if your attorney's like, no, we should ask for 30 mil. And the investigator's like, you should take 20 grand. Go with your attorney, obviously. The investigators are not, they don't really have your best interest at heart. Happy ASS Creature says, you're looking great, Vince. Thank you. I am on the mend. F cancer indeed. I agree with Killis and Wick. Happy ASS Creatures, did you get your special cows yet? The Highland Burgers? No, I have not gotten cows yet. I was at the top of the live stream. I kind of mentioned the farm has been a little bit not on hold. It's obviously been going, producing like 200 meat birds, broilers this year. Increased my egg laying flock, breeding pigs, pasture pigs, coon pigs specifically. It's going great, but we didn't get any cows. We are changing farm managers due to some issues. You can rewatch the start of the live stream. We'll post it later. New farm manager, a little more capable of dealing with large animals. Our old farm manager was terrified of pigs even. And I had some experiences watching him interact with cows. wherein he seemed petrified. So, we delayed things a little bit until we had somebody a little more comfortable with the bigger animals. Carmen Chappelle 2595 says Microsoft Copilot helps with documents. Okay, just remember that when you're using AI, it can certainly disrupt attorney-client privilege, according to a finding in federal court in New York. The airlock says, can I sue my supervisor personally for harassment, withheld pay, disciplinary threats, unprotected coding, attendance penalties, denial of benefits, unequal treatment? I mean, you can sue them for claims. So if that's tied to discrimination, retaliation, sexual harassment, or any other viable claim, yes, you can certainly sue them for those mistreatment issues. But the way you phrase it here, it kind of makes it sound like you don't have a claim because you're talking about like disciplinary threats. That's just management. Like if I go to one of my employees on the farm and I'm like, hey, if you keep saying the farm is yours, I'm going to have to let you go. Is that a discipline threat? Yeah, it is. Is it illegitimate? No, it's very legitimate. Like that's well within my rights. That's just management to some extent. Happy ASS Creature says, racial discrimination isn't worth much money, so it's hard to find a lawyer. Listen, I've certainly made money on racial discrimination cases. I don't think they're low-value claims. Gonna take a short break because we've been going what have we been going? 2 hours and an hour and 40 minutes. We're taking a short break. All right, I'm back. All right, we don't have too long left. We got about 16 minutes left. I'm going to start hopping around a little bit. Interstate 8492 says, looking great, sir. Love your videos. Hope you're doing well. Thank you very much. I'm on the mend, bouncing back. They think I've got at least 5 years to live. So, bully for me. Oh, speaking of bullies, the woman on my office floor, doesn't work for my firm, who told me I'm not a man because I had a poke bowl for lunch in order to tiramisu dessert because I'm trying to eat a lot of calories. I lost 65 pounds during cancer, so I'm trying to put a little weight back on. She complained that I bullied her by recounting the story of how she told me I was not a man in a video. I didn't identify her. I didn't use her name. I didn't really give any identifying characteristics about her besides that she was a bit of a mooch who just kept coming to my office asking for free drinks because I have a large store of beverages in my office. She feels I bullied her and went to her boss and complained that I was bullying her. And her boss was like, shut up or I'll fire you. And I never like to see the employers, be hard on employees, but sorry, I did find the allegation I was bullying her for just recounting what she said to be pretty spurious. I'm not, how do I put this? I'm not worried about my manhood, I guess is what I'll say. but I'm also not like, I don't think it's cute or funny when some lady is like, "You're not a man." Oh, okay. Thanks for that. Nobody asked. All right, let's find the next question. Sneebarg says, AI is not great in the software industry either. It can be good, but it's not great. See, I thought software industry was one of the best industries for AI, where it was the best. So that is surprising to hear. Thank you for telling me that. Interstate 8492 says, how strong is my case in regards to my employer dismissing my doctor's findings in regards to returning to work under no restricted capacity and only going with their IME saying I should be restricted? I don't know. I don't know how good the IME was. I don't know how good your doctor was, but certainly it sounds like you're in the realm of having a case, and attorneys would probably want to hear you out. C-Note 1906, it's good to see you. You have a question. Hi, Vince, looking good. Thank you. My California Fed wrongful termination retaliation case has been sitting with the judge for 1.5 years. She simply won't rule on the motion for summary judgment on her desk. Feeling helpless. Suggestions. 1.5 years is not that long. It happens. You could talk to your attorney, but there's really nothing your attorney can do to speed things up. Speeding up, trying to like push on that judge can have consequences, both for you and for that attorney. So I don't know. I don't know that I recommend it. Yusufel Zain 4050 says, question, what are your thoughts as a professional on the AAA employment arbitration rules that came into effect May of 2025? Let me be diplomatic here. I do not criticize the American Arbitration Association because they are currently my employer. So in this very public forum, I'm not going to deride them. And I'm not saying that I would deride them, but I'm just telling you, like, I'm not going to answer this question because I like money. And I think that AAA does generally a very good job. It's one of the best arbitration authorities in the country. And I think it handles the employment arbitration stuff better than any other arbitration authority that I've seen. Vastly spirited jams, in my opinion. As we mentioned, Chris Kwok works for Jams, and I'm just not impressed. Just my opinion. And so my answer to this is going to be lackluster, and I apologize. Right. Zeus Life Media 5373 says, hi, Vince. How significant is termination during or around an accommodation discussion interactive process? Very significant. Can that materially strengthen an ADA failure to accommodate or retaliation claim? Absolutely. Absolutely. Yeah. I mean, that could really strengthen the case. Harold Anderson says, why is it so difficult to find attorneys willing to go against a public university? Because public universities spend crazy amounts of money. They lie, cheat, and steal. And they have deep, deep pockets. And they don't, how do I put this? They often don't care about how much money they lose. They care about their reputation more. Excuse me. Sorry. So apologies. So what you're going to find is some universities, most universities, would rather lose a $3 million verdict than settle and have someone write a little article saying, hey, they settled. They got people watch the docket, right? And then reporters report on the docket. So they would see the settlement, take it as an admission of guilt, and then do a little story being like, hey, this public university is not as woke as they claim because they had to settle this claim. And then the public university finds that allegation of not being properly woke to be much more meaningful than the loss of millions of dollars, believe it or not. Okay. I'm just going to go through and pick out some random. Oh, Choose Compassion says chicken tendies for $12. No, thank you. And I love Popeyes. I agree. Trey Day says, I wish your firm could have given me a reason why you didn't take my case. That's a service I'd love to provide you. Did you ask? There's no like messaging feature on YouTube like this. So like I would want you to like privately message me your name so I can pull it up, or your phone number in our system, and I can get you an answer, but I don't know how we do that here. What I would say is if you want to email or contact whoever you were communicating with at my firm and let them know I said I would try to give you a reason why we didn't take the case. I'm happy to tell them that that is accurate and to look at whatever went down in the intake level. I don't know if I saw your case. I don't know if another attorney saw your case. Sometimes, listen, there's cases that come in that just so completely fail to state a claim, they don't even get to the attorneys. Like if you contact us and you're just like, I'll give you an example from the last couple of weeks. Somebody just basically contacted our firm, was like, I effing hate white people. Let me have attorney time. We were just like, yeah, that's not how this works. Like you need to have a claim to get attorney time, and you didn't state a claim there. Like you hating white people sounds like the white people might have a claim, but like, what's your claim? You have to share something about your claim. Otherwise, it's just you wasting our time, and specifically the time of these highly compensated attorneys who I pay. And I got to be honest with you, not compelling, right? Like I want free attorney time. Yeah. Like if you have a claim, sure. If you're just a jerk or you're like not stating a claim, no, I'm not just throwing money around for funsies here, A happy ASS creature says they turned me away at first, but when Knight was terminated, they gave me an offer. Trey Day says, now I know why. I don't, that's not usually a reason for us. So I don't know, but could be, never know. RC479 says, hi, Vince, would you please give an example what constitutes age discrimination? And would you give an example, please? Thank you. Wishing you the best with your health. Thank you. Very kind of you to wish me good health. Okay. So under the federal law, if you are 40 years or older and you are treated negatively in the workplace, so you face negative workplace consequences because your age is 40 or older, then that is age discrimination. Here's an example. You're working at Popeyes and manager comes in and is like, Vince, let's say I'm working at Popeyes and the manager comes in and is like, Vince, you're 43. You're too old for this job. You got to go. You're fired. I just got fired because I was over the age of 40. Under the federal law, that is age discrimination. That is a claim. Now, age discrimination can expand in definition in different jurisdictions. I'll give you an example. New York City. If you're targeted on the basis of your age, whether you're over 40 or not, any age, right? Let's say somebody says, we don't hire 20-year-olds at Popeyes. That is potentially age discrimination in New York City. Is it a great claim? Is it a valuable claim? It's not great, but it's a claim. Because the New York City human rights law doesn't specify what age. If you're targeted on the basis of your age and you experience negative workplace consequences, that is age discrimination. The end. That's all it is in New York. Okay. One last question. Choose Compassion says, I have the best stories. That's very kind. I don't know if that's true. I don't know if I can live up to that. Arkansas 001 said, my workplace has less than 15 employees at that location, but employs 10,000 plus employees around the world. Does Title VII apply or not for discrimination? Title VII applies. Spiritual Ark of Noah says, they even mentioned in detail that defense has recordings, yet I'm the one with the recordings. They're taking advantage because I have no lawyer. Soon they think they can get away with it. Oh, so they think they can get away with it. I'm sorry to hear that. FactView 11 says, hi, Vince. In employee as patron case, when bother HR, I guess you probably have both HR and service provider conspire to terminate you, how would that lawsuit go, please? Well, what's the claim? I guess, yeah, I mean, you're kind of asking me a very vague question, and I can't really extrapolate from the information I have. I'm sorry. All right. Let's see. Money PPPPPP says, what's your opinion on Phillips and Associates firm? High volume firm. I know Bill Phillips, nice guy. We have an attorney in our firm who used to work with Bill Phillips, Jesse Rose. Marjorie Mesidor, who's another attorney in New York, has her own firm, used to work at Phillips and Associates as well. There's some really good attorneys over there. Ryan Arce, I believe, is still there. He's very talented. There's also some young associates who maybe aren't that well trained or experienced yet at Phillips and Associates, but generally Bill runs a tight shop. Bill runs a tight shop. They're not gonna take cases that aren't valuable, though. They're on a pure contingency, and if a case doesn't look good, in my experience, they're probably gonna drop it. But that's the business. Like, if the case isn't gonna make money, you can't really just chase loser cases, you know? Rafayette Tokarim 1671 says, how to contact you to discuss a matter pending the EEOC. I submitted a rebuttal already. Well, you can go to www.nycjobattorney.com, talk to our intake people. You can't speak to me directly unless they schedule you a call with me. But if you show them a case that they find to be significantly appealing, They will schedule you attorney time with one of our attorneys, possibly with me. All right, everybody. That is 2 hours and 40 seconds. I had a wonderful time with all of you. I had a lot of fun. I hope your holiday is going well. I hope you remember the true meaning behind Memorial Day. And I wish you all well. And regular videos to resume tomorrow. Take care. Bye-bye.